Hello everyone, and welcome to the last lecture in the research component of RWA. In this lecture, I will be discussing the structure of the federal court system and case law. In class, we will review some of this material. We're also going to be doing some classwork with case law as well as some work with citators. This is the basic structure of court systems in the United States. You start at the bottom of the pyramid and work your way up to the court of last resort. The courts at the various levels may have different names based on jurisdictions, and one of the best resources to look at when you're checking to see what a particular court is referred to is the Blue Book. This is a diagram that I like to provide because it provides so much information about the different courts and how they work together. Remember, like the pyramid, this works from the bottom up. That is, cases start at the bottom and can work their way up to the top. This may be one of the slides that you print off and hold on to. So I will focus most of the attention on federal courts because you can apply the structure to all of the state courts as well. There may be some title changes as we will discuss later in this lecture. Trial courts are where it all begins. They are the lowest level of court and handle all sorts of legal issues. Each state has anywhere from 1 to 4 federal district courts. Michigan, for example, is divided into the Western and Eastern districts. The cases heard in the federal circuit courts are reported in the federal supplement. I feel it's prudent to mention briefly that there are both official and unofficial reporters. Official reporters are published by the government entity, and unofficial reporters will be published by Thomson West or Lexis or some other legal publisher. The intermediate appellate courts handle appeals from the lower level courts. In the federal system, there are 11 circuits covering groupings of states. Cases in these courts are reported in the Federal Reporter. This is another slide that may be helpful to hold on to. I actually have one posted to my wall. This shows the circuit groupings. Some of them may not be that intuitive, so that's why the chart is handy. At the top of our court pyramid is the court of last resort. For the federal system, that is going to be the United States Supreme Court. The U.S. Supreme Court will hear cases on appeal from the lower level courts. As you learn in civil procedure, they are a court of limited jurisdiction, and there are a few cases which actually make it that far. These cases are reported in 3 different reporters, each listed on the slide. When I'm tracking a Supreme Court decision, I actually use SCOTUS blog. It can be found at www.scotusblog.com. It will provide you a layman's analysis of the case, the status, and links to amicus briefs, oral argument transcripts, and opinions. This free source shouldn't be overlooked. So what is case law? How do we get case law? As we are all aware, when individuals have a controversy, they take each other to court. The resulting opinion, if it gets that far, is case law. Cases form the common law, and the common law exists where statutes and regulations don't govern. Cases also interpret statutes and regulations. So one of the biggest questions is, there are so many cases out there, how do I know which one to use? Well, there's a weight of authority that needs to be recognized. Mandatory authority is binding, that is, you must follow what the court holds. Then there's persuasive authority, which is non-binding. So what does that mean? Well, you don't have to follow what the court says, but you may want to use it to persuade a judge to follow that same line of reasoning. So how do you know what is mandatory and what is persuasive? You're going to look at the jurisdiction of the court and then the level of the court. So if I'm in Michigan, I'm looking for Michigan court opinions, not necessarily for California opinions. So where do you find cases? Well, cases appear in reporters. As with statutes, there is an order of publication. It starts with a slip opinion, the first official appearance of an opinion, usually issued by the court itself. Then comes the advance sheet, which is more widely distributed and has a full text of a number of recent decisions arranged chronologically. And then what follows is the bound volume, which consolidates several advance sheets arranged chronologically and usually contains an index or a table of contents. Like I mentioned before, there are official and unofficial reporters. The differences are listed on the slide. This may be reminiscent of codes to you. Remember annotated and unannotated codes? Well, this is the same basic concept, only with cases. So each system may publish their own cases. Think of the US Supreme Court again. There's a reporter that only publishes SCOTUS decisions. Same thing with Michigan. There's a reporter that publishes only Michigan Supreme Court decisions. So let's take a moment and go back in time for a minute. Back in the day, think the late 1800s, databases such as Westlaw and Lexis didn't exist. There also wasn't a reliable system for disseminating court opinions. This really doesn't work well in our system that relies so heavily on precedent, right? So the West brothers decided to come up with a system where all of the cases within a certain geographic area were combined and published. And so was born the West Reporter System. The country is broken up into 7 geographic areas, and West publishes federal and state court opinions in their respective purporter. Advanced sheets are published first, and when there are enough opinions to bind, they publish a new volume of decisions. Regional reporter citations are frequently used in law reviews and other such publications. The difficult part is that you can't tell which court it came from based on the reporter alone. It's important to include a designation indicating the state court and level in the parentheses with the year of the decision. This slide just shows the citation formats for the various regional reporters. You can note that some are on their second or third series, which is similar to addition. Basically, the volume numbers start over again. Here you can see that you really can't tell from which state the decision is coming from. This is what makes what appears in the parentheses so important. So the following few slides compare the names of 2 state-level systems, Michigan and New York. The functions of the courts are the same, but the titles may differ. Again, if you want to see what a court's name is, a great resource is the Blue Book. And here are the names of the intermediate appellate state courts in Michigan and New York. And here are the courts of last resort for Michigan and New York. Note that the court of last resort in New York is referred to as the Court of Appeals, as opposed to Michigan, which refers to their court of last resort as the Supreme Court. So there's a basic structure of a print reporter, and I'll hand out a sample in class that outlines where each of these parts appears, and we'll talk through it. It's important to note that the headnotes are not technically part of the opinion. They are added information from the editors and shouldn't be cited. Same goes with the syllabus. Unpublished opinions. These prove to be very confusing. You may ask yourself, how do we know what unpublished opinions are if they aren't published? Well, they're published, but they're designated as unpublished by the court. Opinions are designated as such at the discretion of the court and may be done because the court doesn't feel that that opinion should have any precedential value. Sometimes it's because the application is so specific that they don't see how it could possibly be of use to another party. Some say that cost actually plays a role in a court's decision to publish a decision as well. Students frequently have uneasy feelings about unpublished opinions, and you can feel free to bring these up in class. What I need to tell you is that unpublished decisions should not typically be cited. It's important for you to check the court rules in your jurisdiction to determine whether you can cite an unpublished case, and if so, how you should cite it. There are 3 basic ways to search for a case. You can search with a case in hand, which means someone just gives you a case with a citation. Another is to use headnote outlines. So if you're already in a case, you can locate similar cases by looking at the headnotes. And another way, the way you are all probably familiar with, is by using search terms and filters to track down a case. A question that may still be going through your mind is, how do I find the case that I need? I've mentioned it before in class, but West and Lexis have created systems that essentially link similar cases. These are the topic and headnote systems. We'll see examples in our homework of what these look like and how they work. I like to think of them as really fancy tables of contents or indexes. This slide just describes the West topic and key number system. Again, we'll see examples in class and work with them. They can really be an invaluable tool. You can access the Westlaw list of topics and key numbers by going to Westlaw Next, then to Tools, and then to the West key number system. We will work through a Citators assignment in one of our classes. I just want to mention them briefly because they can also serve as indicators of other cases you may want to use in your research. They also provide an indication of whether the law you're looking at is still good law. So in class, we'll have some discussion of case law. We'll then work through an in-class exercise. In our next class, we'll then pick up wherever we leave off. We will then discuss citators and work through an exercise on those together. If you have any questions, don't hesitate to let me know. I'll see you in class.